I'm Ben Meiselas from the MeidasTouch network. I believe it was Newton's third law. For every action in nature, there is an equal and opposite reaction. Well, sometimes the same holds true in law. So the MAGA Republican Supreme Court justices and the MAGA Republican Federalist Society members who just achieved the elimination of college admissions and university admissions, factoring in diversity into their admissions process, may be in for a rude awakening. On Monday, one civil rights group filed a complaint before the Office of Civil Rights, a complaint regarding legacy admissions practices at universities like Harvard, which are not merit-based at all and which allow individuals to get into universities simply because of their last name or because of their connections. MAGA Republicans are claiming everything needs to be merit-based, merit this, merit that. But when you actually look underneath the hood, that's not what they are doing in practice, because they have been supportive of legacy admissions. They have been supportive of exams and other practices which really don't measure how smart an individual is or how much merit someone has, but what it really measures is how much resources somebody has to be trained or taught to do a specific exam. I'm going to get into the complaint that was just filed by this civil rights organization, but also the NAACP, in addition to the civil rights group. They've backed the efforts of this group, but they've also been pushing to an end to legacy admissions and other pernicious practices at colleges and universities, which do not favor merit-based systems. So the one thing I want to talk about is this case, Students versus Fair Admissions versus Harvard, and there was a companion case, Students versus Fair Admissions versus North Carolina. The way it's generally described as it eliminated affirmative action. And the way I like to talk about it here on the MeidasTouch network is I don't really use the term affirmative action, because affirmative action, how most people think about it, really never has existed. Because I'm sure when most people use it colloquially, affirmative action, they believe it means that a minority candidate gets into a school over a non-minority candidate, or it means that certain points are given to a minority candidate in their application to give them a step above other candidates. That's not okay, actually. That's not what the law is. I mean, I personally believe that it could be all right, but the Supreme Court has outlawed that practice. The Supreme Court, dating back to 1978, has found that quotas are unlawful. So a college can't have a quota system. A certain amount of minority students get in. That was deemed to be unlawful. That case was a case decided in 1978, the Bakke case. And then there was a 2003 case, Grutter versus Bollinger, which says you can't have any point system attributing a certain amount of points to a minority applicant. In 2016, this was affirmed in Fisher versus University of Texas, which basically says no points or quota systems, but diversity can be a factor that colleges focus on. Promotion of diversity, one of many factors colleges can consider, but you can't give it any specific point-based value, just the idea that diversity is important. I totally agree with that premise. That seems to be something that most Americans agree with. Most American corporations agree with. Apple, all the big tech companies, the American Medical Association, they all talked about how critical diversity is at colleges for everybody. The American Medical Association said it will save lives. You will literally kill people if you take away diversity in the college admissions process, since it is vital to have people serving the communities that they come from. Corporation said it's going to make America anti-competitive in the economy. But 6 right-wing Supreme Court justices were like, whatever, screw it, we don't care. And they overturned the precedent, which was affirmed as recently as 2016. So I would call it super precedent on top of precedent. But look, ultimately, and here's the thing that the right-wing justices say. They go, we need an entirely merit-based system. It's all based on merit. And so if you factor in diversity, that's not race neutral, and that's not based on merit. That's the logic that they try to give, but ultimately it's based on a logical fallacy, since legacy admissions has permitted people who do not have the merit to get into schools to get into schools. So what civil rights groups are saying is, well, we could have lived with legacy admissions provided diversity could be a factor. In many ways, it kind of evens out. But now, based on what you're saying, Supreme Court, legacy admissions should be a violation of your own new decision, because in legacy admissions is not race neutral. You are picking out people who have a legacy at the university. And by its very nature, legacy admissions, what does it mean? The legacy of colleges is that Black and brown and other groups of people were banned and prohibited from going to college for a lot of our history. And so if you're basing it on legacy, that's not race neutral in and of itself. Here's the article by the Associated Press talking about this complaint that was filed. Activists spurred by affirmative action ruling challenge legacy admissions at Harvard. A civil rights group is challenging legacy admissions at Harvard University, saying the practices discriminates against students of color by giving an unfair boost to the mostly white children of alumni. The practice of giving priority to the children of alumni has faced growing pushback in the wake of last week's Supreme Court decision ending affirmative action in higher education. The NAACP added its weight behind the effort on Monday, asking more than 1,500 colleges and universities to even the playing field and end legacy admissions. The civil rights complaint was filed Monday by Lawyers for Civil Rights, a nonprofit-based Boston group on behalf of Black and Latino community groups in New England, alleging that Harvard's admission system violates the Civil Rights Act. Quote, why are we rewarding children for privileges and advantages accrued by prior generations, said Ivan Espinoza Madrigal, the group's executive director. Your family's last name and the size of your bank account are not a measure of merit and should have no bearing on the college admissions process. Opponents say the practice is no longer defensible without affirmative action providing a counterbalance. The court's ruling says colleges must ignore the race of applicants, activists point out, but schools can still give a boost to children of alumni and donors. The complaint submitted with the Education Department's Office for Civil Rights draws on Harvard data that came to light amid the affirmative action case that landed before the Supreme Court. The records reveal that 70% of Harvard's donor-related and legacy applicants are white, and being a legacy student makes an applicant roughly six times more likely to be admitted. Other colleges have these same practices. The complaint alleges that Harvard's legacy preference has nothing to do with merit and takes away slots from qualified students of color. It asks the U.S. Education Department to declare the practice illegal and force Harvard to abandon it as long as the university receives federal funding. A spot given to a legacy or donor-related applicant is a spot that becomes unavailable to an applicant who meets the admissions criteria based purely on his or her own merit. If legacy and donor preferences were removed, the complaint adds, more students of color would be admitted to Harvard. And the NAACP also launched a campaign aiming to get universities across the nation to promote campus diversity by calling on 532 public and 1,134 private colleges and universities to end legacy preferences, eliminate racially biased entrance examinations, recruit diverse faculty, and support low-income and first-generation students with scholarship and mentoring, among other steps. Quote, it is our hope that our nation's institutions will stand with us in embracing diversity, no matter what, said Derek Johnson, president and CEO of the NAACP. And regardless, the NAACP will continue to advocate, litigate, and mobilize to ensure that every Black American has access to resources and opportunities they need to thrive. And look, I know the term affirmative action is used in this article and is frequently used. The reason that I describe it, though slightly different, is I understand a discussion, a debate that could be had is, what do you think about quota systems? What do you think about a point-based system where certain applicants get more points than others, a quota system that has certain numbers of applicants? I will at least get that there could be a debate there. Let me just say that. However, the idea that diversity should be a factor in the way colleges handle their admissions, the fact that colleges want to promote diversity, to me, no matter what side of the quota debate you are on, we all should believe that diversity is a good thing, is an important thing, will help our economy, will help colleges, will benefit everybody who goes to the university, who goes to the college, that will be a net plus no matter what. And for the Supreme Court to say, well, no, it's we strictly care about merit-based, but then have this flagrant hypocrisy that exists, well, as I mentioned, every action in nature, there is an equal and opposite reaction. And here we are now seeing that the Supreme Court may have undermined some of the very systems it was trying to protect, some pernicious systems it was trying to protect. Imagine if colleges and universities say, we don't care about the SATs anymore, we don't care about the ACTs anymore, we don't care about people who have 4.12 GPAs from private schools. We don't care about legacy admissions. We just want to hear essays about the quality and character of candidates. What if that becomes the outcome here and you get great students? I bet you're going to see the right-wing Federalist Society, MAGA Republicans just flip out on that. So we'll keep following what's happening here, but an interesting response to what I think is a bad Supreme Court decision. I'm Ben Meiselas from the MeidasTouch Network. Hit subscribe. We're on our way to 1.5 million subscribers thanks to your support. Check us out at patreon.com/MeidasTouch. Wherever you get audio podcasts, subscribe to the MeidasTouch podcast. Have an excellent day.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.